Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. I have a brand new guest. I'm very happy to have on Deandre Arnold. He is a father, an equal rights advocate for parents involved in family court proceedings, and potential political candidate. He is the chief organizer, see if I can say
Mhm.
this in English, of group called the Fathers' Rights of Georgia, as found on Facebook, the CEO of a youth group based in Atlanta to educate young adults about the importance of family to counter motherless and fatherlesshood and alienation of children, including the founder of a 150-member organization called the United Coalition Family, and a self-taught scholar on the United States Constitution. His mission is to bring about a uniform transformation of unjust custody and support laws that he feels will save America's future. Here's he's here to discuss with us today his personal plight involving shocking claims of ongoing corruption in the state of Georgia, involving local and state levels, including the family court system, which he states has resulted in public corruption complaints to law enforcement alleging threats to his safety and security as a result of this corruption, and a legislative proposal that he believes will not only put American families first before the state's purse wallet and save the seed corn of our nation, but to ensure that no other parent, mother, or father experiences or undergoes this type of systematic abuse that he is currently up against. And I so welcome you,
Thank
Deandre
you, thank you,
Arnold.
thank you.
And how did you? Okay, so you started studying law and the
Mhm.
Constitution, and then you formed these organization and youth groups. This is a mammoth task. How did you get
Yes.
involved in this? This is amazing.
Yes, indeed. Yes, indeed. Yes, indeed. I love to go into that. But first off, let me start by saying, thank you. Thank you for having me on the show, providing me a platform to, get my story out to the public. I think the work you do is very important, even when you don't have to do it. So, I just wanted to start off by first saying, personally, thank you for this and this opportunity.
Thank
You know,
you.
um, Yeah, so yes, to first off, to add to what you were stating, I'm originally from Georgia. I grew up in the rough parts of Atlanta. I never expected to be such, actively involved, let alone concerning myself with such magnitude with, gathering 100 members for a collective cause, with organizing the Fathers' Rights of Georgia organization, or, even drafting legislative proposal, to reverse what I believe is cultural and legal structures that has injustices involved within it, the family court system and government overall. So like you stated, I just didn't wake up and get directly involved in this, let alone decide to spearhead these movements, alone, or to even draft a legislative proposal. To be honest, about 6 years ago, I didn't even know what a motion was, let alone know how to draft a legislative proposal, So what initially got me involved in family court and studying law, period, was due to the fact that, out of nowhere and for no good reason, my daughter ended up in a whole entire state, another state, without me knowing her whereabouts, around the age of 1. So, I missed her first steps. I, had to initially watch her grow up, through family members of, my my daughter's child's mother. So, that kind of put me in a situation where I had to figure out how to get my child back because, at that time, as I initially learned, I didn't have any rights to her whatsoever. So, of course, I reached out, and learned from an attorney that I had no rights to the custody of my child unless I filed for legitimation. So, the attorney was more than happy to do so, but you know, for a price of $8,500, however. So, so I still remember me asking him, hey, what do you think about equal custody? And without hesitation, he kind of looked at me. We didn't look at me. He kind of going through a Zoom and basically said, well, I can't promise you equal custody is kind of how things go. The most I can promise you is visitation. So, after I immediately logged off to the law library I went. And, that kind of put me kind of back for a minute. But within about 8 months, after studying with the grace of the Most High, I was
Mhm.
able to secure 12 days a month with my daughter, with equal summertime and split holidays. And I did all this without an attorney. And a court, actually signed and granted this order in 2017. And it's pretty much what, me, my daughter, my child's mother was kind of going through for about 5 years. So that's initially what got me started studying law in the first place. I didn't know what a motion was. I wasn't even concerned about a court. The only thing I knew about court was, traffic court. So, as soon as I lost my child, that put me in these books. And, while learning and studying law, I picked up on a lot of other things as well. So, that's what initially got me involved. But what still feels as if it's recent, all my hard work and the joy my daughter was experiencing, in this parenting plan that I consider is equitable, um, and that I was able to secure in the state of Florida, was ripped apart, on October 7th, 2021 by a Henry County Superior Court judge named Brian O'Mara, as a result of bias and corruption in his specific court. So, this bias and corruption, however, is currently pending. The allegations concerning is currently pending in the Northern District Federal Court, in which I'm a pro se plaintiff. And these are actually major allegations that I'm alleging that the municipal courts in the state of Georgia do not have the constitutional authority to convict, let's just say, criminal offenders for state traffic offenses. And a ruling in my favor could possibly result in a district court order prohibiting and, let's just say, invalidating all state traffic offenses in the city courts in the state of Georgia. This could all come about by the likes of someone who looks like myself. So I would just say, and what I'm going to get into is that how this bias and corrupt order that arose from this judge in Henry County Superior Court all correlated to my actual involvement with municipal courts in the state of Georgia. So, I like to go into that, but it's going to require me to go back about 3 years up until now. So, I guess for now, do you have any questions for me so far?
What was the judge's name?
Judge Brian O'Mara of the Henry County Superior Court.
Okay, Brian, and you kind of got soft there with his last name.
Yes, Brian O'Mara.
Okay.
Mhm.
Hmm.
Yes, indeed.
N-
Yes.
Go ahead.
Yeah, so I have to start off by telling you exactly how this all began, me getting involved with these city courts and how this all came about. So, in October of 2020, notwithstanding the fact that I had, challenged the constitutional authority of the city courts, and my conviction overall, I alleged in this federal court, this federal suit that the city court had denied me my right to jury trial and right to counsel, by neither inquiring nor receiving a waiver of any waiver of right to counsel or jury trial. I was convicted of a stop sign violation, which sentence was suspended on the condition that I perform conditions of probation. I alleged that my appeals were thwarted by court clerks who collectively left voice messages that gave me legal advice to my detriment to file an appeal in the wrong court, which was the court and the conviction that arose out of the conviction. I allege that records requests for video and audio evidence of these actual trials that not only denied me right to counsel and right to jury trial, but also would have proved that they were, I will use the word, misleading other individuals out of their right to counsel and right to jury trial. I allege in this open record suit that the audio and video for this to act as evidence was actually, prevented, stalled, and frustrated under the Open Records Act. And all of this was done to prevent me from overturning my conviction. So, all of this was occurring around the same time I was undergoing, probation conditions, which I've also alleged in the federal court violated the 13th Amendment, in which I was duly convicted. So we're talking about claims that I'm presenting in this federal court that, number one, they never thought a proceed would have the actual intellect to litigate, let alone even know how to do it alone by himself and proceed. So, so now while all this was occurring, unbeknownst to me, my child's mother will file a modification action in the Henry County Superior Court in March of 2021 to relocate with my daughter back to the state of Florida. This was the same court who was actively involved in a growing conspiracy to prevent me from overturning my city court conviction. So around the time, my child's mother actually filed this modification in this court, um, there were actual things that were going on that was going to, arise into an actual large and growing conspiracy that I would soon learn to be so large have threats to my safety and security. So an open record suit was eventually filed against the city of Hampton for that audio and video evidence in the Henry County Superior Court that proved not only did they convict me, but were convicting others without jury trials and without right to counsel. At the same time, my child filed a modification of custody action. This case was also pending. So both of these cases were pending at the same time and were under Judge Brian O'Mara. And on August 10th, 2021, I filed a recusal motion of this judge in both of these cases because of my growing knowledge of his participation in this actual conspiracy with others involving to prevent me from overturning my city court conviction. So one of the claims made in this motion of recusal are allegations that he was assigned to he was assigned as judge to a writ of habeas action filed in the Henry County Superior Court in July of 2021. However, there was no case number filed to the action. There was no actual filing of the action whatsoever. However, I learned from multiple clerks that he was so-called the assigned judge and no other judge could be assigned to the case. Mm-hmm. So, I alleged that certain clerks had motive to sign him due to the fact that not only was he involved in this specific action, but he was actively involved in delaying the merits of my open record suit to retrieve the audio and video evidence from the city of Hampton. So all of these were claims that I alleged in this motion of recusal on August 10th in 2021. And today I can say to you that the writ of habeas has been destroyed or concealed by the Henry County Superior Court because I have called down there and asked for the writ of habeas, and they have stated that they have no knowledge of it. So we're talking about things that happened in 2021. So now after the final trial of my custody case that took place in July 2021, on October 7th, 2021, these recusal motions were denied in both of my cases, the open record suit and the modification of custody action. This judge entered a final order granting relocation of my child's mother in the custody action, which also included a falsified child support order that I'll go into soon. So in this actual custody action, I would just like to state the things that I alleged against the mother. And so the people can kind of, just understand exactly what actually transpired in that case. I presented evidence in this specific case that the mother was found in contempt for 25 days of custodial interference, just months prior to her filing the action. I presented evidence that she had assaulted me in front of my child in July of 2020, even prior to her actually filing the action. I allege, pretty much everything going back from all the way to 2018 up into 2021 to prove a consistent and persistent failure and inability to co-parent and alienation. I allege things that tried to run me over with a vehicle. So much things talking about alienation, being criminally trespassed from my home, all of these things I was presenting against her from at that moment, I knew not from a judge who were not even, who was not even concerned on what I was stating. He came in with one thing and a predetermined outcome, and he decided that's what he wanted to do. So, these were all the things I was alleging against her. However, I believe this judge took advantage of the fact that he had no proof that anyone, let's just say, proof of anyone recording or taking down the hearing in that actual case.
Mhm.
Now, I would just like to state that, for your listeners, there is case precedents that actually states that an individual can record his own hearing. Um, there's also actually statutes, possibly in your state. I know they're in the state of Georgia, which states that an individual can recreate his own transcript. So not all the times an individual may need an actual court recorder to actually take down a hearing. And I learned this from an attorney who's no longer here. He was a powerful attorney out of Chicago. Didn't speak to him personally, but he used to have a lot of Zooms in which he used to kind of go into his case and express things he was going through. And he's the one that actually kind of put me onto the fact and gave me case law, which actually let me know that, hey, we can record our own hearings in these actual courts. However, I won't go into neither whether I did or whether I did not, considering the ongoing conspiracy that I'm up against. But I would just like your individuals to know that there is case precedent that you can record your own hearing. So let's just say, just to do a quick recap, I had two cases in the Henry County Superior Court: an open record suit that was assigned to Brian O'Maro, and a modification of custody action that was assigned to Brian O'Maro. I filed a recusal of this judge out of both of these actions due to his participation in a conspiracy. He denied these actual specific, let's just say, recusal motions, and also entered a falsified child support order. And I would just like to state that at the time he entered this child support order on October 7th, 2021, he had no knowledge, nor did anyone else that he was involved with had any knowledge that I knew that the order was falsified. Um, so on November 7th, this is when things took a turn. I first arrived in the Henry County Superior Court and filed an appeal of this actual denial in my custody action. In this actual appeal, I requested transcripts and evidence of proceedings. And so at no time did this court or judge, again, have any knowledge that the support order, that I knew that the support order was falsified. So I first arrived, filed my notice of appeal in the actual Henry County Superior Court, and then I later arrived downtown in Atlanta at the Court of Appeals building to file a discretionary appeal from this judge out of my open record suit. So let's just say, as soon as I walked into the actual building, I gave the actual state trooper my ID. He kind of looked at my ID, searched it in the system, held on to it for quite some time. There were actually a few officers kind of sitting out there, and just say the energy was off. So after I kind of went to the back and filed my actual appeal, soon as I walked out, these officers were now armed with AR-15s.
Yeah.
And was surrounding me and basically told me to, hey, put your hands behind your back. You have a warrant out for your arrest. And mind you, I had no idea what this warrant was, how it came about. The only thing I knew that these individuals were telling me to put my hands behind my back. They had searched my ID in the system, and it pinged the warrant. So, this is when I alleged in federal court, what I'm now alleging in federal court, that Marty Matthews, which is a probation officer contracted out of the city of Hampton, filed a revocation hearing on August 9th, 2021, and deliberately failed to give me notice of this hearing in order for a warrant to be placed upon me, and cause my arrest. So this was a false imprisonment that I'm also alleging in the federal court, and I have the federal court case above me right now, scrolling above my head. So as soon as I arrived to jail, You know, first I would just like to state that it's a state trooper. I don't know her name, but I would just say that this state trooper might have been God sent. There was kind of conversations going on about me going to Fulton County first instead of going to actually Henry County. So, I was kind of having a colloquy with this officer, telling her that I had major implications going on with the Henry County court. And I had no idea how this warrant got on me. And I believe these were all nefarious acts. I basically told her, you don't get arrested at the Court of Appeals building on a warrant that you know is placed on you. The individual that I'm alleging all of these conspiracy actions against is the actual individual that I went into the building to file the appeal on. So you're talking about an individual who gets arrested at the Court of Appeals building on a warrant out of an actual court involved in a conspiracy in which you are there to file an appeal to remove him out of your case for the conspiracy. You get what I'm stating?
Yeah.
So when I arrived to jail, after I kind of told the officer these things, she made the decision to not go to Fulton County and take me straight to Henry County. Soon as I arrived to jail, there was nurses that immediately came out. Um, Within 45 seconds of me taking a COVID test, they had all figured that, hey, we need to isolate you and keep you away from the let's just say the processing. You may have COVID, sir. We need to, isolate you and keep you away from everybody else. I did not get out of the patrol car. I actually, told them, no, I'm not being taken away from everyone else. You need to take the test over. At this time, my hands behind my back, and I'm texting, all of my family members, letting them know what's going on, letting them know where I am.
Mm.
And about 4 or 5 times, I guess the fifth test, they decided, well, he's not getting out. We're going to have to drag him out the car, then take him to the isolation. So let's just, I just figured that they probably figured themselves, let's just take him on a process. So as soon as I get into the processing, in Henry County Sheriff's Office, these individuals, they only allow, I don't know if it's just for me for that day, but they only allow individuals to have phone calls about 3 in the morning. So lucky for me, um, after spending hours in this actual jail and getting my first phone call, this is when I learned that the warrant was based out of Henry County involving Marty Matthews. This is due to the fact that I was able to contact my family members and get them apprised of the situation and tell them, how I ended up in this situation. So
Mm-hmm.
Marty Matthews, the individual probation officer who deliberately failed to give me notice of a revocation hearing, was actually the individual now demanding $700 from me from my immediate release. So in this instance, I had two choices to make. I could sit in this jail and I can challenge this action because, like I'm alleging in federal court now, the city of Hampton did not have the constitutional authority, let alone did not even have the right to counsel or did not receive a waiver of right to counsel or the right to jury trial whatsoever. So I could sit in there and I can stay for a few more days and challenge this action. And or I could immediately pay and for my release. So, and be stripped of my self-help and self-protection. So again, I would just like to emphasize on that, placed in prison, you are stripped of your self-help and self-protection. You are, put at the, let's just say the actual duty to protect you now is placed in the hands of others, and that being the Henry County Sheriff's Office. And we all know the corruption that occurs when it involves individuals behind bars. We heard the stories of a lot of individuals in these actual specific circumstances that the public seems to talk about for some time, and then it never gets done systematically. Nothing ever gets done systematically. So I made the decision to actually have my family members pay the $700 for my immediate release.
Mm-hmm.
I was released on November 8th, 2021. So if you have any lawyers listening, I would just like to state that at this time, um, they're looking at an individual that they believe do not have any legal knowledge. So let's just state that this was possibly to this arrest was maybe as a part of another conspiracy to subject me to, let's just say, Heck versus Humphrey. And your attorneys may know what that means. So in December of 2021, I filed a federal lawsuit in which I'm alleging all these claims that occurred against me. Um, on December 7th, 2021, I filed an amended notice of appeal, and at this time I excluded transcripts and evidence of proceedings. I would allege in this federal court also that my direct appeal would be delayed for over 100 plus days. When I went down there to file the appeal, these individuals did not immediately file a pauper's affidavit that I had submitted with it. This was, in my opinion, in which I have alleged in federal court, was to stall and delay supersedes of the appeal. So now what I'm learning now, what I have learned now, is that a day before my filing of this federal suit in 2021, I would later learn that the department would file a contempt action against me. Mind you, this contempt action was filed less than 2 months after Brian O'Mara falsified a child support order. So all of these, all of the actions of the judge began to come centerfold, approximately in about 2022. I began to realize that this tyrannical act was, not only in concert with others to aid and assist, preventing me from obtaining video evidence and, let's just say, overturning my conviction generally, but it had something to do with avoiding liability and making it easier to arrest me based on his knowledge of an unlawful registration of a support order that occurred in 2021 involving me, the Department of Human Services Division of Child Support Services, in which he was the presiding judge. So all of these actions began to, come centerfold. So I began to realize that his act of falsifying records was an affirmative act to possibly to test the wherewithal of my knowledge of the validity of this 2019 support order that he knew was void. So and when he was certain, this is what I believe, when he was certain I had justifiable reliance on the falsified support order, he acted in concert with the child support services to falsely imprison me and possibly worse. And all of these acts was collectively sworn to in a federal writ of habeas action, in which I've alleged that this contempt hearing was knowingly filed unlawfully and in bad faith. And, let's just say, act as a vehicle of state-created danger to propel me unlawfully into prison to strip me once again of self-help and self-protection. So I allege this in this federal habeas action that the Division of Child Support Services utilized this actual contempt hearing to pursue me after I filed a motion in the actual appeals court to supplement the record. So what do I mean by supplement the record? In this modification of custody case, as I initially stated, I was tendering in evidence all of my specific claims. And there's an affidavit that proved that I maintained the majority of my child's custody from March 2020 up to June 2021. So this specific affidavit was tendered into evidence without objection. So this is what I was motioning this appeals court to actually order the trial court clerk to bring up this affidavit so that I can use it on my appeal. So the appellate court denied this motion. And at the same time, the appellate court was consistently misgendering me. When I say misgendering, they use words like her instead of him, or let's just say she instead of he. On information, so on information and belief, I believe that they may have done this to probably alert my child's mother for whatever reason. Maybe they figured I wasn't sending her the things and they wanted her to defend the actions, or they just possibly looked down at the evidence and possibly considered to themselves that there's no possible way that this man could have possibly lost, so it had to be her appellate.
Oh my
So
gosh.
either one of the ways. So now I alleged in the federal court that this contempt hearing was pending. and was to occur on May 18th of 2022. So now, open records requests for any and all action taken on my child support case were being ignored at the same time that this hearing was allegedly pending. So I made open records requests in April of 2022 for any and all action taken on my child support case. I made it to the Department of Human Services Open Records Department, and I asked the local division of child support services, both of them collectively, for any and all action taken on my child support case. So now, what I'm alleging in this federal habeas suit is that the Department of Human Services and Division of Child Support Services concealed this contempt action from me and ignored all open records requests for a period of 4 months while this actual case was pending. So you have to understand something. This is very familiar to the other act that happened in involving the probation officer who executed a, let's just say, a revocation hearing against me and deliberately concealed notice from me. So I began to realize that this may be a second go round at what occurred in the actual let's say municipal court. So overall, I alleged in this federal court that for the second time, a threat to my safety and security, which ironically, both of these cases now have been put up under the same judge. So these are the things that I was alleging in this actual court that was occurring. Um, 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 the state created danger arising from a judge who deliberately falsified records as a means to act in concert with the Division of Child Support Services to actually bring a contempt action against me when they were possibly sure that I didn't know that the 2019 support order was falsified as a means to place me in jail on information and belief for reasons that I believe I have challenged the constitutionality of city courts in the state of Georgia. So all of these things were occurring against me, and they had utilized a support order in my child's name, the child that I was fighting for, to actually imprison me or worse. And these things have been alleged in a federal court. I've also filed an open record suit against the Department of Human Services, which suit will prove that these individuals indeed deliberately ignored and concealed not only this contempt action, but ignored my open records request while this contempt action was pending. So, what I'm alleging is that the state of Georgia and its high-ranking officials have all utilized the state judiciary and its state agencies as an instrument of oppression to come after an individual who was attempting to file redresses of grievances. We're talking about things that have that opened the wounds of why this country went into a revolution. If I remember correctly, it was the forefathers who actually gathered together and decided that they were going to file a grievance against the king and declare their independence. A couple of years after that, more men realized of the importance of adding everybody and ensuring everybody was equal up under that. So, yes, I said a lot so far. Do you have any questions?
It's these falsified child support orders. I'm sure there's a boatload of other people that have falsified child support orders and exes that are not revealing their true incomes. It it seems like one party has to give all the financial information, but the other party doesn't have to. I guess it's who you know
Mhm,
in that courthouse.
mhm.
That game was played with me. I'm sure it's being played with other people because there's so much collusion in these courthouses.
Yes. Yes, indeed. In my Pacific case, this order was falsified as a means to possibly throw me in jail after, the first act didn't work, so, this we're talking about corruption that is just totally intolerable, intolerable. I think it's corruption in every single court. Somebody may get mad or pissed off, but to utilize the state judiciary and its agencies to come after a citizen who is simply trying to, redress grievances. We're talking about things that send this country into a revolution.
Mhm.
This is essentially why we got into a revolution in the first place. Not calling for a revolution, but just stating that these individuals and their actions are to be taken seriously because these are the actual things in which we got a constitution in the first place for individuals acting as tyrants and utilizing their positions of power to oppress others. So, the whole entire system will come down and crumble down upon its head if we allow these individuals or any other individuals to continue to do these actions. This is not, what I would call a civilized society.
Mhm.
We cannot have a civilized society if you have foxes, guarding the hen house. And this is exactly what is occurring in my specific situation. So, not only occurring this, I would like to get into the fact of, what I have alleged, not only in public corruption complaints, but what's actually going on right now, which I would call maybe a purposeful foreclosure of my relief. So I want to get into the JQC. So a lot of individuals don't know who the JQC is. They're called the Judicial Qualifications Commission. They are an actual entity out here in the state of Georgia. And these individuals are responsible for reviewing judicial complaints filed against judges. So in my specific circumstance, I filed a judicial complaint against Brian O'Mara on December 9th of 2021. Um, when I actually filed this complaint, I did not receive any type of correspondences. I did not receive any type of notices that state that, hey, we received your complaint. The only thing I received is an email from, I believe is a good person, Christian Birch of the actual Judicial Qualifications Commission. But however, I have alleged that an individual inside of the JQC, I won't say her name, um, but her name is placed in public corruption complaints, was asking me for evidence of this conspiracy too early in the stage. So, you have in the JQC, you have a stage in which if the allegations are true, then it should go to a preliminary investigation where now you can present evidence. This individual was asking me for evidence in the actual beginning stage. So, this was kind of suspicious to me because now you have to understand. I have alleged that this judge did not have any proof that anybody recorded this hearing.
Mhm.
So now this individual is now asking me for evidence. So just being kind of wise and understanding why an individual would be asking this. I'm doing my part and letting my state know what's going on. Hey, this is out of the ordinary. So a year later, one day after I called to check on this actual judicial complaint, the JQC dismissed this action, basically finding no wrongdoing. So you got to say that an individual judge falsified a child support record. So I would just like to say, how did he falsify a child support record? First off, there was no petition to modify child support filed on the record and no prayer for relief filed on the record. So what this act as was a falsification of a child support order and falsification of a proceeding. Um, if in, no, and I actually have case law that actually states this. I think it's Petro versus Romeo, in which it unequivocally stated that a prayer for custody does not include a prayer for child support. And in order to actually file a modification for child support, that has to be, what I read with my study, that has to be an actual modification of child support or prayer relief for. There was no prayer for relief and there was no modification. So essentially, this judge falsified this specific proceeding. The JQC found no wrongdoing, stated that they could not actually investigate these type of claims. I submitted a motion for reconsideration, I believe, in January of this year. I don't think it has been ruled upon, but that is the JQC. So now I want to get into the claims that I've alleged in the federal court. I've alleged in federal court that the offices of Stephen C. Jones, he's an actual federal judge who actually, let's just say, is well known about the abortion bill in which he prevented all abortions in the state of Georgia. I allege that his offices were involved in mail tampering. So what I mean by that, I allege that around the time that I was attempting to serve the city of Hampton, which includes their prosecutor and the judge, the actual summons for the judge was actually removed out of the actual mailing. So you're talking about destruction of mail and theft of mail, all of these things. I provided all of these to the FBI and Department of Justice. Within 3 weeks, this judge actually got out of my case, and the judge who was recently confirmed, Sarah Garrity, federal judge Sarah Garrity, was placed in my case. So far, I'm alleging that the JQC has possibly deliberately foreclosed obvious relief. And at the same time that I was litigating my federal lawsuit, going through all these things, the federal court was involved in allegations of mail tampering. So now let's talk about going to the individuals to get them to investigate. So after these individuals did not investigate, and I was sure that the state of Georgia was just going to ignore and acquiesce to these claims, I filed a private warrant against Brian O'Mero. And I did this on May 14th of 2022. So I filed a private warrant on Brian O'Mero, and the crazy thing is that allegedly all of the Henry County Magistrate Court judges recused themselves from the action, and the
Oh,
case was
nice.
assigned. Yes, the case was assigned to an individual by the name of Dr. William T. Simmons. Now, his job and duty was to assign the case to another judge to actually hear the action. They stalled this application warrant or application for arrest warrant for about 2 months. And what I later found out is they stalled this warrant 4 days before the hearing that was being concealed, an open records request. So they did the hearing. Well, the case was assigned to a judge, I believe, July 14th, who actually denied it on July 14th. The hearing was actually to occur not on May. I think that was a mistake, but the hearing was to occur on, I believe, July 18th. And I filed this warrant on May 14th. And the application warrant was dismissed and assigned to a judge on July 14th. So you're talking about me filing an application warrant against a judge, and this actual warrant hearing was actually stalled and delayed until 4 days prior to the hearing that was being kept from me. So now we're talking about these specific things that are occurring with this actual appeals court. And just recently, my appeal had a ruling on it. And once again, I'm alleging clear falsification of records, a refusal to recuse, and the actual appeals court, the same appeals court who was deliberately misgendering me, actually found no error in the lower court. So basically, everything that he did in his lower court was basically all lawful. All of the claims that I'm alleging against him right now. So all of these things were occurring around. All of these actions were taking place at the same time. So what I consider these actions to be are an attempt or an indirect way to utilize the government offices and its judiciary and agencies as an instrument of oppression, not necessarily to directly do anything physical, but to foreclose an individual who is constitutionally and lawfully and legally entitled to relief, but to delay his relief because of what it may mean in regards to filing some type of potential claim against these individuals to possibly subject me to some procedural foreclosure. You know, however, I would just like to state that all of that actions that I'm alleging right now that they have done against me, I've been able, with the, you know, with the grace of God and with the help of the Most High, to actually get around everything they're doing. He's been giving me the knowledge to actually go through these things and fight these specific things. And I would just say that if it wasn't for my knowledge, that these individuals would have possibly been successful on their illegal incarceration to actually do whatever they were actually planning. But I believe my walk is divine. I believe God has put me on this specific course for a specific reason. I think everything happened for a reason. And I believe that is why I'm on this specific walk. So for anybody that is interested in my cases, you can go down to my Facebook page, Georgia Conspiracy. I have all of my Pacific claims. Even you can even view my actual, let's just say, my Pacific federal filings in my Pacific case. My most recent filing was an actual motion to stay these corrupt state proceedings, which is still pending in the federal court. My federal lawsuit, in which I have challenged the constitutionality of city court or state convictions in city courts, is still pending. My open record suit, in which I have alleged that these individuals have stalled and delayed open record suit and ignored my open record suit at a time that this warrant, not warrant, but at the time that this hearing, contempt hearing was pending, is still pending. None of these things have been placed in order on it, but I can say that based on the things that I've experienced, I'm starting to realize and recognize that I will go so far to say that we are dealing with sleeper cells. When I say sleeper cells, we're talking about corrupt entities and corrupt individuals who are placed in offices to actually work with other corrupt individuals to bring about an instrument of tyranny on their own citizens. So I don't I don't want to go so far as to say the government is corrupt, because I believe the government works perfectly and fine. It's just the individuals in the offices in which government operates are the individuals who are corrupt. So we just have to kind of remove these individuals. So I would like to go into now my specific legislation that I have proposed, um, which I believe will stop and prevent all of these actions from occurring, that I believe will stop and prevent any individual mother, and I believe in my case, for utilizing child support as a means of retaliation. Um, you know, um, there are a lot of fathers on child support right now who are basically placed on child support not because he was an absent father or not because he did anything, let's just say, out of the ordinary in which he was supposed to be on it, but because you had a mother who was retaliatory. You also have individual mothers who are placed on child support, who are dealing with these same specific things just as much as fathers are dealing with. So, I actually drafted this proposal and I call it the Parenthood Act of 2022. And what I wanted to act as is a specific legislation to operate as the basis or the framework or the groundwork or the foundation for uniform change across the several states. So me and you spoke about, we're talking about equity. When I say equity, it's 50-50. It's just evident. You're dealing with all these things in which constitutional rights are adamant and protected, but a lot of individuals do not know that when it comes to mother and father, they consider these rights basically deadlocked or conflicted, which removes the any impediment on any alleged constitution. So these are things that I want to actually protect, and I think that my legislation does this, specifically for custody. I believe that at the beginning of any type of hearing, all individuals ought to be granted 50-50 custody. There should be a presumption of 50-50 custody as soon as an individual walks in, and after that individual is deemed a fit parent, now it should be determined whether that individual can actively and ably participate in such a joint custodial arrangement. Um, I think that that will actually keep these actual things, and which you're hearing all over let's just say the television today about mental health. You they're ignoring where all of these actions arise from. You're talking about crime involving juveniles. All of this can be statistically brought back to being deprived of their mother and father, or having type of alienation, dealing with two arguing parents. And you have the courts who come in, and instead of acting as an individual who is genuinely trying to mitigate these specific arguments, they come in and they monetize these arguments by actually removing a mother or father from their child for financial gain. In the long run, in the temporary run, yes, the state will receive billions and billions of dollars, but you're dealing with, we're talking about this specific bill. I think, let's just say, this has to pass because these actions are threats to national security. You're talking about the academia of our children being, let's just say, descending all over the course of years, and all of this can be traced back to the actual child being deprived of his mother and father. You know, we have China surpassing us in the academia situation. You have other type of countries that are way smarter and way ahead of us in the technology field. You're talking about mental health in the country. You know, all this talk about guns and removing guns out of the hands of individuals' hands, but we're ignoring that, uh, it starts at the home first. So if you remove a integral part of the family unit, then you're bringing mental health issues into the mind of this child, in which he will get older, in which he will go to school and deal with these situations, and which he feels that now he has to take a gun to school and kill children, or he's dealing with a situation where he's lack his father or lack his mother, and he's acting out and becomes a juvenile, gets involved in crime, and ends up taking the life of an individual, or puts himself in a perpetual situation in which he's going through the criminal justice system. Um, all of these actions have been ignored by Congress, and I believe because of the money. So however, I think my bill will not only help in the long run in custody, as far as custody, but I believe that my legislation proposed will actually increase child support amounts. So I like to go into this as well. So I'm just going to, come out and say it, that it's a lot of individuals that are on child support, and I believe that the government are depriving these individuals or any type of let's just say privity amongst themselves to take care of their child without being forced to. This is putting men and women in a situation in which they just you know, uh, they shouldn't be in the first place. This is why I think, and my legislation will work wonders. If you got anybody that is on welfare or Medicaid, then the state has all right and authority to pry into your business. The state should have the right to recoup any type of payments from you. However, it should not just, get into a wealth transfer from one parent to the other. It should come out to both parents, and both of these parents should actually split these things equally. It should be some type of program that should be set up to provide these type of bases. Now, let's just say, um, doing away with the Medicare and any type of welfare assistance. Let's just say you get into a parents who are not on these things, but you have a father who have not, he has not been there. He has not been, trying to even get his child. He hasn't even attempted to file legitimation whatsoever. And the mother files an action against him and says that, hey, Your Honor, this guy hasn't been around for 3 years. I've actually placed a plan together to say 3 year, 6 year, 18 year, pretty much like Joe Biden's three strikes you're out. So, for the first 3 years, that father can be placed on child support. And what I've drafted my legislation proposal to do was actually to incentivize his paying on time, his or her paying on time. Instead of putting the father on child support for 18 years, this father is now placed on the 3 year plan, in which he or she cannot willfully miss one payment within that actual plan whatsoever. Um, but at that time, He has all the lottery winnings can go to him. All of his insurance lien claims can go to him. His wages are not being garnished. His license cannot be suspended. If he willfully missed one payment in that actual 3-year plan, he cannot go to jail. All of these are incentivizing an individual to actually pay child support on time. And you, instead of situations where you get with a father who just you're destroying an actual father with 18 years of
Mm.
child support, destroying a mother with 18 years of child support. And most of the time, these individuals should not be on child support in the first place, because I believe the state should actually give the parent the privity to prove that, hey, Mr. Government, hey, Miss Government, I can take care of my own child without you forcing me to do so.
Mhm.
And if I fail in that regard, then you have all the right up under your interest to do whatever you want to do. And so let's just go into now the 6-year plan. If the father willfully misses one payment, then the judge has the discretion, once again, to place him on a 3-year plan again, or to put him in a 6-year plan, where if he willfully misses 2 payments, he can now go to prison. All of his earnings are now subject to garnishment, lottery winnings, lien. Let's talk veteran benefits. You know how they have everything set up now. I believe these individuals could take the air out your tire or put a lien on that. They will. So all of these will be subject to let's just say child support enforcement up under the 6-year plan. So if that father willfully misses 2 payments within that 6-year plan, then now he goes on an 18-year plan. So now, what I have essentially designed this is to actually incentivize not only reunion instead of separation, but actually incentivize on-time payments for fathers who don't want to be there. I don't think the state, if the state is so concerned about money, I don't think you'll have a problem finding absent fathers if you basically I believe do these things the right way. If it's such a problem with, I understand the complexity between Title 4A and Title 4D. The states are put in a situation to voluntarily comply with Title 4D in order to receive Title 4A funding. If Title 4A funding is actually removed, then the governor is placed in a position to possibly increase the actual taxes on his citizens. Not to provide any fault for the governor or say the governor is at fault, but I think the only state who actually done anything about this is actual Kansas, and an attorney may be well prized for that specific case I'm speaking about. But I understand that complexity. So this is why I stated that anytime an individual asks for anything of the government, now the government has the right to come in and put you on some type of program to recruit those benefits, because the state cannot actually continuously to afford to take care of your child when it's your job. You get what I'm stating?
Mhm.
So that will put us fathers who I believe are, active, attentive, willing, and able, and want to be in their father's life, will keep us out of this actual 18-year destruction in which these things can not only be weaponized by your child's mother, but weaponized by a government who wants to come after a father, not only for his knowledge and to litigate, city court claims, but knowledge in other areas as well that they consider very lucrative. So I have a legislative proposal that I would like to produce. And this is why I gathered all of these individuals together, this 150 member organization, the Father Rights of Georgia group. The reason I'm forming a youth group, the reason I'm doing all of these things. And I'm doing all of these things at the same time that the state is actually utilizing child support as a weapon to prevent me from litigating grievances in the actual courts, federal courts and state courts. So I believe it was all by divine design, and I believe God has me on this walk, and I'm going to continue it, and not going to fret or fold.
I'm so glad I had you on to talk about this. I actually met you through TikTok,
Yes.
and I think that's really I've met a couple of people through TikTok that have been on my podcast, and,
Mhm.
the child support is being weaponized, and a lot of people want the Title 4D completely gone,
Mhm.
and, um, you know, um, I don't know how to say this, but I don't know how you know, it's so corrupt with all the incentives it's bringing in.
Yes.
I mean, Okay, for instance, I have a case, and I can talk about it because I've had him and his attorneys on my podcast twice, and he's been on it by himself. The Jim Shock case. Um, you know, the judge took away his Second Amendment rights, made him take away his
Mhm,
antique rifles, things he inherited from his father, for no good reason.
mhm,
And she's literally weaponized the Second Amendment to withhold his child from
mhm.
him so he can be forced to pay a boatload of child support. And it's okay for the mother to keep her guns and live with a felon. I mean, it doesn't make any sense how these judges are ruling.
Mhm.
And what is also frightening is in the federal court system, no one, these judges are not or magistrates are not looking at exhibits, evidence, and just ruling them irrelevant.
Yes.
I know I'm throwing a lot at you because this is gonna be another podcast. You
No,
know,
no, 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 no. Yeah, I love to talk about this topic. We it's kind of crazy, and this is why I'm actually doing this legislation to not only change the laws, but to actually, put mothers and fathers in a situation in which, they don't have to kind of they can be protected by statute. I think there could be the argument that an individual who lacks education in this area cannot be reasonably or possibly apprised to know all of these things in an actual court and can be taken advantage of in that manner and actually prejudice him. So, this is why I want the actual statutes to, heighten the protection. So to remove any type of false allegations against any mother or child at all, against any mother or father, to try to remove the child, to actually get into the fact that hearings, video recording here. I mean, this could be done. It could be so simple. You know, video record the hearings. Why does an individual have to pay for a transcript and make it so hard to actually get his evidence? There should be actual video of the hearing, and that video could be transcribed into paper to actually be brought up. And instead of an individual being having to have the knowledge to say, "Hey, can I have a court reporter or a motion for a court reporter?" The state should already have that in place. You're dealing with individuals who work 40 or 50 hours a week. They have not a clue of what a motion is, and they're coming into court, and the only thing they know is, okay, I'm just going to do it the best way I can. I
mhm,
don't have $5,500 for an attorney. You know, once again, these things have to happen because, as I say, it may be a temporary fix for to receive billions of dollars to recruit your Title 4A funding, but you're talking about long run consequences in which this country is going to be overrun. So we're
mhm,
when I say overrun, we're talking about in the educational area. You're dealing with mental health in this country that's going to affect everybody.
mhm,
It's just I kind of wrote a book about this. Wrote a book in length about a lot of stuff, to be honest. But just think about the situation in which a judge, right? A judge takes away a man's father or a man's takes away a child's mother or father, and this mother or father and this child gets raised up, right? Without the mother or father, develops mental issues and dealing with his parents. Um, um, you have a situation in which this individual gets involved in crime, gets so entrenched in crime by being deprived of the type of love that could have came from one father, that he finds that love in someone else or a gang or a street gang or some type of individuals that he can relate with. And, they get involved in acts of villainy in the society. And now let's just put in a situation in which the judge who actually ruled um, um, in that bias or prejudice or order, let's just say, for instance, he's out walking with his family, and this is 10, 15 years later, and that same individual who has developed those mental issues and actually got involved in acts of villainy is now has him in his crosshairs. So now that judge's family is about to get killed. Let's just say, due to the fact that this individual is going to rob these individuals now, right?
mhm.
Let's just say he's going to rob these individuals, and that ends up in the death or murder of the judge's whole entire family, attempting to protect his family.
Mhm.
So now it goes all the way back to the fact that the judge himself, could have avoided this situation if this individual, if he would have ruled in a way that did not deprive this individual of his parents, which would have put this young child in a situation in which he would have never even having to grow up with these mental issues. You get what I'm saying?
Right.
So so yes, I'm kind of writing a book about that that kind of goes into this and many other things as well. And it has to be stated. And I think we ought to put judges who may be behind the scenes pressure. We don't know what's going on. Not to say the judge in my case, I think he's just the principal architect of an act of tyranny. But let's just say for judges who want to do the right thing, who may be pressured by the fact that you're dealing with something that is much more bigger than we could possibly imagine. You're talking about Title 4A and Title 4D, reciprocating units. Hey, we'll give you this if you take this from them, and it's
Mhm.
going like this. And the judges are now put in a situation in which now they have to protect the interests not of the national government but of the state. So we have to pass legislation to actually make it more easier for the states to do their job. And it's an individual by the name of Julia Carson. And I actually want to work with her as well. My legislation deals with specifically just custody and child support laws to act as the uniform basis across the several states to bring about this change. Um, um, Her actual legislation deals with Title 4D, and she's actually amending Title 4D to provide incentives for not separating, but actually bringing parents together. Because if you
Mhm.
bring parents together and increase the family unit, now you remove individuals from the need to get on welfare. You get what I'm
Mhm.
saying? And then the state spikes its own interest because now you're trying to prevent the mother gets on welfare. Now you want to come after the father. So you take all the money from the father, and now the father gets on welfare.
Yeah.
So we're so we're not doing anything but acting against our own interests. And anybody who wants to, let's just say, oppose equal parenting bill, I believe is involved in an ancient, going back to 200 years, takeover of this nation from the inside out. And I think that Americans ought to be very worried, concerned, and aware of who these individuals may be. And like the
Mhm.
great Deandre said, believe them when you see them.
Mhm. Well,
Mhm.
we had a bill in Pennsylvania for shared parenting, but it was so poorly written and it would actually increase litigation. And I wrote a letter voting against it because it would just increase litigation. And it actually said in there that child support would be voluntary. And it's
Mm.
never voluntary. I don't know where they're getting this. There was also two other factors that were not. Oh, I can't think of them right now. When we do our next podcast, I'll let you know. But
Yes.
some of these bills are poorly written. Um, it's very hard to co-parent with someone who just won't co-parent with you. They're so um, psychologically damaged themselves. They will not. And this is why there is litigation.
Hmm.
And, a child deserves the love of both parents. And in my case, we were 50-50 for 10 years until he remarried an individual that actually worked in the courthouse and inserted herself into our business. And that's what led me into the family court system. But that's another podcast in itself. But, it can be done with normal people. Normal people can co-parent.
Yes, indeed. Yes, indeed. Normal people can co-parent, should co-parent. That's why I started the youth group to kind of, just kind of talk to these people and say, hey, you all get older and have a child. Let me let you hear these stories. Don't get involved in this. Mothers, let me let you hear stories from children that were deprived from their
Yeah.
father or mother,
Yeah.
so you can hear their stories. So when you grow up, to utilize your mindset and your wisdom to say, you know what, the village is more important than this 18-year money. Um, um, uh, uh, your offspring and your bloodline is more important.
Mhm.
So that's kind of why I formed this youth group, and I
That's
think that I
great.
can actually get this bill passed. I actually want to work with multiple senators. I've already spoken with congressmen. Um, 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 this is kind of why I started this 150 member organization to actually, let's just say professionally and, legislatively work with the actual legislator to actually pass this bill. And I think that if they look at it and understand, what's going on um, all over America, specifically in my state, in which these individuals, and I'm alleging, have utilized child support to actually, come after a father.
Uh-huh.
So, yes, we're dealing with a lot of situations, but I can guarantee you the next time we possibly speak, the conversation will be much more different, and I will have basically a lot of historic things to possibly assert and tell you. So we're
Well,
going to talk about that soon.
oh, yeah, I can't wait for our next podcast.
Yes.
So don't jump off, but going back to that bill that I wrote a letter about, it's dead in the water. No one ever voted on it. No one did anything with that bill of
What
50
state? What state was that out of?
Pennsylvania.
Yes, yes, yes. See, this is what I know. Because we have a bill in the state of Georgia, HB 96, that's equal parenting bill. I'm actually trying to spearhead an actual passing of that bill. So, like I was stating, the states know exactly this is so crazy. This is what's actually going on across all the states. And some states are actually, bringing equal parenting in, but it's not, like you said, it's still, you know, it still involves some type of litigation where an attorney can now just utilize these laws as a means to increase his legal fees. But I actually have something for that in my legislative bill as well to actually for an individual to provide a private right of action against him, for things are just out of the ordinary. Let's just say this father is just absolutely fit and this attorney is involved in any type of falsification or increasing litigation in which can be absolutely determined, and there's a private right of action against this attorney. So they might put the attorney in a situation and say, oh, I'm not going to,
Yeah,
So
yeah.
it's my legislation is designed to actually help every occurrence. But going back to what I was stating, most states understand that hey and it's so sad, if we allow these parents to be equal, we're going to lose funding for Title 4E. Somebody has to get on Title 4D because we have an incentive and this is how we have to do this and this is how we have to do that. So you have the individuals behind the curtain who know what's really going on, who gets in the back and make a decision and decides to say, well, we're not going to do this and we're not going to do that. So even if the bill you have individuals that have more concern, for that other than, your concern was increased litigation. Um, um, that kind of puts these bills in a halt, So I think this is why I stated that this bill, in which I'm alleging, has to be passed uniformly across the several states. This involves speaking to the House. I think, this can be a bipartisan effort. We're
Mhm,
talking about children here. We're talking about the seed corn of the nation. Our children are literally the future. So if
mhm,
we deprive our children of the best possible upcoming and upbringing they can have, then we are essentially, destroying our own future. So this is
mhm,
why I stated that now everybody knows what we need to do. So now we have to get in a situation and really look at who is opposing what needs to happen.
mhm.
So we have to do this on a collective effort. And, I believe God has me on this divine walk to actually, set this in motion, with a lot of other smart and intelligent individuals that I'm working with right now.
Oh, excellent. Well, I know you gave us your contact information earlier, and I can put
Mhm.
it in the podcast notes. But
Yes.
I'll say again, if anyone needs to contact you, uh, how can they
Yes.
contact you?
Yes, they can contact me at Facebook, Georgia Conspiracy. I have a Facebook page, Georgia Conspiracy. You can also contact me on Twitter, the official Black Arm. I have it down here. The actual should be scrolling at the bottom. You can reach out to me. Um, um, it's better to reach out to me on these. I have my personal information on this. I actually have my phone number on the actual parenting bill that is being, spread all over the internet right now. So if anybody or any congressman or any lawyer that wants to join my organization and get together and try to form some type of basis where we can kind of get this thing pushed through, then you can contact me and you can reach me at those Pacific Hamptons.
Oh, excellent. Well, hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I am your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again here with Deandre Arnold here in the future, because I'll probably have him on next month, and other exciting guests. Thank you very much. I appreciate you.